Here, we're going to talk about the case of Rylands and Fletcher. In Rylands and Fletcher, Mr. Rylands had hired subcontractors to build a reservoir to provide water for his business. The reservoir was built over old coal shafts, which had been filled with earth and soil before he started building. But one of these plugs of earth gave away, and water escaped from the reservoir and into the underground mine workings. The water then flowed through the workings and flooded a mine owned by Mr. Fletcher. Now, the peculiarity of this case is that Fletcher did not have a claim in negligence against Rylands, and that is because the faulty work that was done on the reservoir was not made by Rylands himself, but through his subcontractors. Ditto for any private nuisance claims, because the general rule is that when an occupier employs a contractor to do work on their behalf, the occupier is not liable if any unlawful interference occurs. So, you'll be surprised to hear that Fletcher actually won his claim. But how? Through creating a new tort which later became recognized as the principle in Rylands and Fletcher. When the case reached the Court of Exchequer chamber, Blackburn J. stated, "We think the rule of law is that a person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. He can excuse himself by showing that the escape was owing to the claimant's default, or perhaps that the escape was the consequence of V major or the act of God." This was the birth of a new tort in Rylands and Fletcher. It should be noted that when Blackburn J. laid down this principle, the word damage is actually a reference to damage to property and nothing more. So for instance, physical injury does not come under the principle in Rylands and Fletcher. He notes that liability under this principle can be defended on grounds such as where the property damage was caused by the claimant's own fault, or, as he says, a consequence of vis major, that is, a superior force in Latin, meaning to say some sort of unforeseeable natural occurrence that causes the damage, rather than caused by the thing that the defendant brought onto their land themselves. So we can see from this quote here that Blackburn J. had in mind several elements which comprise this new principle in tort. Firstly, there has to be a dangerous thing likely to do mischief. Secondly, the thing must have escaped from the defendant's land. Thirdly, the thing must have caused damage on the claimant's land. Fourthly, the defendant must not be able to prove that he or she has a defense, such as the damage being caused by the claimant's own fault, or the damage or disruption being caused by some sort of unforeseen natural occurrence, i.e., an act of God. Blackburn J. also made clear what he thought to be the rationale behind this new principle. He states, "It seems but reasonable and just that the neighbor who has brought something onto his own property which was not naturally there, harmless to others so long as it is confined to his own property, but which he knows will be mischievous if it gets on his neighbors, should be obliged." When the case got appealed to the House of Lords, Lord Cairns essentially agreed with Blackburn J.'s reasoning and decision. However, he added one additional requirement to Blackburn J.'s formulation of the principle. He states, "If the defendants, not stopping at the natural use of their clothes, had desired to use it for any purpose which I may term a non-natural use, for the purpose of introducing into the clothes that which in its natural condition was not in or upon it, and if it consequences of their doing so, the thing came to escape and to pass off into the clothes of the claimant, then it appears to me that that which the defendants were doing, they were doing at their own peril." So this essentially adds an extra requirement to the tort in Rylands and Fletcher. So even if a thing was inherently dangerous, whatever the term means, So long as the defendant can prove that he or she was using that dangerous thing naturally, he or she would not be found liable. In summary, the tort in Rylands and Fletcher has been restated in more modern terms in the later case of Transco and Stockport, which neatly explains the different elements required for liability. There the court stated, an occupier of land who can show that another occupier of land has brought or kept on their land an exceptionally dangerous or mischievous thing in extraordinary or unusual circumstances is, in my opinion, entitled to recover compensation from that occupier for any damage caused to their property interests by the escape of that thing, subject to defenses of act of God or act of a stranger without the need to prove negligence.